Well, thank you, Jocelyn, and thank you also to Victoria for all your work in arranging this. It's a pleasure for me to participate in the webinar series. We're in London at the offices of White & Case, where I have a role as Special Advisor in the global oil and gas practice. The subject today, as Jocelyn mentioned, is international gas contracts. So Jocelyn is kindly going to be moving the slides on for me as I take you through this. These are contracts, and as with all contracts, there is a governing law to be decided. Very often in international gas matters, whether that's pipeline gas or LNG, English law is a choice of law. And today's seminar is based on English law. That is typical of many common laws, so wherever you're sitting, I hope this is going to be appropriate for you. Principle of freedom to decide the terms of the agreement and pretty much absolute enforcement of that agreement once that agreement has been made, save to the extent that the parties agree to reliefs. So it's a corollary of the freedom of contract that you also have a freedom to provide your own reliefs and exceptions, and if you don't, then the court won't help you. English law has a tradition of holding parties to the bargains they make. These contracts are typically long-term contracts. Now, whether long-term is 20, 25, 15 years, within the context of the law, these contracts are a long term. And what they have to address is changing circumstances. And one of the key themes during this presentation is of how contracts made in 1 year and enduring for many more address changing circumstances. So what we're looking at is the interpretation of agreements, the performance of those agreements over time, and then the enforcement of those terms. So Jeremy Bentham quote, "The power of the lawyer is in the uncertainty of the law." Looking then at interpretation, English law will be seeking clarity and certainty and the establishment of enforceable rights and obligations. It's an objective test, the relevant words in the factual and commercial context. What was negotiated, what was intended, what the parties meant is not the test, an objective test. The context is necessarily relevant, but the extent to which it's relevant will depend on the circumstances of the contract. So what is sometimes crisply mentioned is text or context in relation to interpretation. And what I think is also significant here, particularly in international gas contracts, is the culture of the parties. So the governing law is one thing, but culture and approach is another. And a question for you to really hold in mind, because it will feature in this presentation, is to what extent is a contract relational? The case of Chemco Leasing, I'll let you have a look at that to read, but the principle that that's making is that what the courts recognise is that in some areas, and particularly long-term relational contracts are an example here, the parties can't actually agree and write down with certainty what their agreement is. Parts will be left over, and that's not a difficulty, but it does mean that when the parties disagree on what was meant, then, as Justice Staunton said here, it's unusual to ask the judge what the parties meant objectively when actually they meant that he was going to decide. So, great case to read. Wittgenstein, meaning of a word is its use in the language. So here we come on to this idea of text or context, or what is often called abstraction in the law. And the typical approach in the law is of text before context. So rules which enable background to be ignored. You may well have come across the parole evidence rule, signature rule, mirror image rule. Essentially, these are looking at excluding background circumstances and concentrating on the text of the agreement, not the context in which that agreement is made. Prior negotiations and subsequent conduct will tend to be excluded. There's a resistance to implied terms, and the test for implication of terms is a high hurdle in English law. What does this lead to? Well, it leads to reduced fact-finding and, on the face of it, fewer disputes. The next slide, this is really, I think it's quite good fun. Text or context. If you read this, you could be left wondering what it is about. The reality is, this is a description of the rules of cricket. If you know that, then this makes sense. If you don't know that, this is extraordinarily difficult. What prevails, text or context? As well as abstraction at law, the parties also engage in this abstraction, concentrating on what is agreed and what the parties write down. And this is one of the reasons why these contracts typically are 150, 200 pages long. Experienced parties of equal bargaining power have the freedom to contract and self-reliance on what they agree. The desire is for all the terms to be in the document. You've seen clauses of no reliance on oral modification, the nom clause, recent cases on those, and also merger clauses. So trying to limit the nature of the agreement to what the parties have written down. Trading and influence is just touching on here not only the agreement which is being made, but the shifts within the industry. And here the international gas business, in part pipeline, but probably more significantly over recent times in LNG. And the change of the participants, the growth of aggregators and traders. So rather than being a delivery from a point of production to a point of consumption, companies such as BP, Shell, Total, increasingly working on an aggregation basis where the delivery of a cargo doesn't necessarily reflect that cargo coming from a particular place. Aggregate acquisitions, aggregate disposals, and trading. And also the participation of companies, commodity trading companies. So you'll have heard of Vitol, Trafigura, and these companies who are now participants in the gas business. Here, there's a concentration on margins, transaction costs being reduced, the growth of master framework agreements, standardization of terms and forms, and particularly credit support and the ability to close out transactions. Today, the principles best come from the long-term contracts, not so much the trading instruments. So that's what we're looking at more than anything. Benjamin Franklin, keep your eyes wide open before marriage, half shut afterwards. Well, that's quite a nice rule in many areas. And as with a lot of these long-term arrangements, relationship matters really count. So marriage analogies tend to come up. What's a relational agreement? Well, long-term shared purpose. Long-term isn't enough. It's a shared purpose, high degree of communication and cooperation, and predictable performance. And it's also matters such as mutual trust and confidence and expectations of loyalty. So these are matters which typically English law has not concentrated on, but in recent times have come to the fore. And long-term gas contracts are strong examples of what English law is increasingly recognising as relational agreements. The bullet point there, difficulties of presentation. I promise you it's not a typo. It does say presentation. And presentation is the principle of seeking to bring tomorrow's circumstances into the present, to write down today what you are expecting in the future. So all the what-ifs, and lawyers and negotiators spend a great deal of their time, what if this happens, what if that happens? We need to put in a clause, some words to cover that, bringing the future into the present. Presentation. Terribly difficult to do, and you inevitably will not be able to foresee everything that's going to be happening. But when a difficulty arises, prices have changed, inabilities to deliver, inabilities to take, then at that point the parties will typically look first at their contract. What does the contract say on this? Looking for the work that the negotiators did at the beginning in the presentation. Have I got a clause which covers this? And if you have, then that may well be accidental more than intentional. Expectations derived from conduct. So this is really development of that same theme, so we can probably move on from that. Expectations from a contract's context. And here, again, what I think is important to hold on to is, in addition to reading the agreement, what is the context in which the agreement is made? Quote from The Godfather, "It's not personal, it's strictly business." Well, here you see the very opposite of the relational theory. And if you've watched The Godfather, then you know that something bad is about to happen to somebody when you hear that. What this is really looking at is the ability to look beyond the words of the contract as written down. So it's not personal, it's strictly business. Once you have entered into your 20-year agreement, are you really then in a position to say, actually, I have no interest in your interests. I'm pursuing my interests solely. And that is the balance that we're looking at today, which is how that sits. Good faith and English law. There is no general principle of good faith in English law. As I mentioned earlier on, English law is if not extreme, then it's certainly towards the edge of enforcing the bargain the parties have made. And whereas many jurisdictions will have implicit good faith in the making or the enforcement of agreements, English law doesn't. But in recent times, there has been something of a move for the implication of good faith in certain relational agreements. And this really is where long-term gas contracts are very relevant to the way in which the law is moving. What the courts look for is faithfulness to a common purpose and expectations. And significantly, English law doesn't attribute general good faith. New York law, for example, under the Code, has a general duty of good faith. What English law looks for is that the circumstances and the context mean that the parties are bound by duties to each other beyond the words of the contract. But that is only derived from the nature of the contract and the words that the parties have used. One of the reasons for, I suppose, touching on this particularly is that obligations of good faith within the English law context typically have arisen in relation to implications of good faith. Long-term gas contracts are one of the rare families of contracts where good faith is explicitly set out. And you only have to look at a few LNG contracts to see explicit obligations of good faith and also explicit expressions of commitment to the contract. The so-called Smut acronym that you'll see on the slide. It's an acronym. Smut obviously carries a connotation in English as well, but this is the spirit of mutual understanding and trust. And many LNG contracts, and particularly in Asia, have a specific obligation that the parties will perform the contract in a spirit of mutual understanding and trust. It's a very strong, specific comment on the approach of the parties, and the written words, text or context, don't capture everything. Yamseng and International Trade Court is the first case to read in this context. Mr. Justice Leggett, in that case, who set out the implication of good faith into English law. So what are the elements of good faith? Performance in good faith, but not negotiation or formation. So In making your agreement, English law, what's the overriding rule? It is freedom of contract. You can prefer your interests absolutely in making your agreement. But having made that agreement, performance may bring obligations of good faith. These obligations are imposed by contract, not public policy, in the way that I mentioned. Not an adversarial activity, but a reciprocal benefit for both. Moving on, and moving on from The Godfather to Star Wars, do or not do, there is no try. And any of you who've seen Jedi Master Yoda and Luke on this, there is do or not do. Well, you won't find a Jedi Master or any other Star Wars character in a long-term LNG agreement. They are full of reasonable endeavours obligations. And what do they mean? And indeed, why are there so many reasonable endeavours obligations? Well, under English law, endeavours obligations are viewed as being meaningful, but they fall short of absolute commitment. So as we saw early on, having made your agreement, the courts will enforce the bargain that you've made. Endeavours obligations stop short of making that bargain. It's a commitment to do what I can in the context, not an absolute promise. And there are expressions of relief also. So just for a moment, it's worth looking at this. If you are going to be held to perform in accordance with the terms of the agreement, then either dilute the obligation, an endeavours obligation, I'll do what I can, but I don't promise to do it, or provide for relief if you can't do it. And the relief classically is called force majeure. Force majeure we'll come on to in a moment. While we're on endeavours for the moment, there's a hierarchy of expressions: best endeavours, reasonable endeavours, all reasonable endeavours, commercial endeavours. You'll find many of them. But what's important is the extent of the endeavour and the certainty of the objective. Moving on then to force majeure. Another quote from Eisenhower this time. Consistent with the freedom to make the contract that you wish to make is the freedom to provide the reliefs, and that really is what a force majeure clause is. English law has no idea what force majeure means. It's a civil law expression, and it's a civil law principle. In English law, it means what the parties write down that it means. So if you wish to provide a relief, call it force majeure by all means, you can call it anything, but the words that you write down are important. And you just see an example here of the type of provision that you'll come across. The nature and effect, well, typically a breach of an obligation and then a relief from the liability that would normally arise from that. For example, as a seller failing to deliver, the seller would then ordinarily be subject to a contractual sanction, money sanction, for that failure to deliver. Well, if the seller can show that it was relieved because an external event that it tried to overcome caused a failure that it couldn't overcome, then a relief from the commercial sanction. The burden of proof is on the party claiming, and what force majeure won't do is lead to a revision of the agreement or termination of the agreement. It's a relief from a breach or a suspension of obligation. It is not in the nature of a civil law hardship arrangement or an ability to recast the terms. Particular considerations with force majeure: delegation and subcontracting. Very often the parties to long-term gas contracts will delegate performance to others. How are you going to ship it? Often that will be a third-party shipper. Many areas of subcontracting. Money payments are almost never relieved. Enough of those. Another good film, The Commitments. What we're looking at here is soul solos are part of the song. They have corners. You are spiralling. That's jazz. What type of agreement are you making? have you captured everything within the four corners of your agreement, and do you know what those are? You know all the notes and they're all in there. Or have you left some things over to be done afterwards? Are you then going to leave it to be made up among the parties? A commitment to the relationship, you're not looking at escaping the relationship, the contract that you've made, but the particular terms are to be derived afterwards. And this is the area of agreements to agree. And as many English lawyers will tell you, an agreement to agree is unenforceable. And that is far too blunt a view in the context of international gas contracts. There are many areas where agreement is left over for another day. It may be something prosaic like measurement provisions. At the time the agreement is made, the delivery terminal is not yet completed, for example. The production terminal is not completed. At that point, it's not unusual to find that those terms are to be agreed by the parties with a fallback of the standard terms of a particular body. Well, English law is really comfortable with that. Or, if the parties can't agree, then the terms are to be decided by a third party, an expert or intervener. And the leading case says very crisply, the law will not deliberately defeat the reasonable expectations of honest men. So if the parties reserve these matters for another day, the court is very, very slow to strike down an agreement to agree. A 20-year contract, it's been in place for 10 years, and the parties meet to seek to agree on a price adjustment. Well, it's an agreement to agree if you look at just that part of the agreement, but the court will put it in its context. Changes of circumstances. Well, as Sterling Moss tells you, things change. And here is really the nub of what we're looking at today, the clash of two large principles of law. The rule of law, the sanctity of contract, and the enforcement of the terms that have been written, and changing circumstances and the ability for the changed circumstances to adapt the nature of the obligations that are made. For some people, this is common law versus civil law, clearly more broad than that. But that's what we're looking at, trying to address. And are we looking at changing the contract or just a relief from breach without an adjustment of the terms? The best area for these, and long-term gas contracts are one of the very, very few places in commodity trading or the law that you will come across these, are price reopeners. Great quote from Donald Rumsfeld, who I won't quote very often, I promise, and for good reason. But there is one area in which his expression, which is a military expression, but it captures beautifully what's going on in a price reopener. There are known knowns, the things we know. So most people are comfortable with that one. We also know there are known unknowns. That is to say, we know there are some things we do not know. And I think most people are comfortable with that one. But it's the third one which really sends people. But there are also unknown unknowns, the ones we don't know we don't know. But it's a wonderful description of what the price reopener is trying to do, because the parties in making their agreement are seeking to look forward for 10 years, 20 years. Well, within that time, markets change, circumstances change, regulation changes. The parties can cope with a number of things. The prices will change in the market. The means of adapting the gas price by reference to indicators for, say, crude oil prices or other gas in other jurisdictions, those indicators can change. But what the parties are trying to cope with was something which is beyond their contemplation, but which so changes the circumstances that it falsifies the bargain that they've made at the beginning. So here you can see the difficulty that English law has in this. The parties are trying to address circumstances that they don't know and to come up with a binding agreement, a binding change, a new provision which allows the contract to move forward. The unknown unknowns. Example of a price reopener, and I've just underlined some of the provisions here. So you'll see words like appropriate, good faith, objective of agreeing, changed circumstances, reasonable endeavours, fair and justified, market outcome, comparable, reflect. Really elastic words, not necessarily given to certainty, and there they all are within 10 lines. So whereas Donald Rumsfeld, I think, does set out quite nicely, although he didn't mean to, the description of a price reopener, Mark Twain, I think, was probably rather more direct on it. It isn't what you don't know that gets you into trouble, it's what you think you know that just isn't so. So, what happens when the time comes when things are adrift? You need to change the contract. One party is suffering, the other party is benefiting. All the good things of the marriage, the courtship, the memorandum of understanding, the heads of agreement, all of those things have now gone, and the parties are in their camps arguing their own corners. And as Indira Gandhi said, you cannot shake hands with a clenched fist. But this is the period in the contract where fists are clenched. International gas contracts will almost always provide for resolution by means of arbitration, international arbitration. Contracts will also include expert determination provisions in relation to particular matters, technical matters, sometimes price. In looking at these provisions, you will also find sometimes references to mediation, although within the international gas business, most companies would say that they will simply elevate the dispute, the disagreement, to different levels of management in an effort to resolve it. What the LNG business and the pipeline gas business have shown in recent years is that these matters are not always soluble nowadays. The sums in issue are just too great. And the arbitrations that have taken place are very many in Europe, and these arbitrations are now also happening in Asia and expert determinations. So are you looking at a judicial process, arbitration, or a matter of expertise, such as expert? Ian McNeill, and in looking at relational contracts, Ian McNeill is well worth reading, but he's also, I think, very sage on dispute resolution and arbitration. If I move forward onto resetting the bargain, and I think this is increasingly relevant within international gas contracts, where many parties over the last 10 or 15 years, in the context of changing markets, particularly in Europe, have resorted to arbitration, adversarial proceedings, and really processes which are inconsistent with a long-term agreement. Because these cargoes, the deliveries are still happening. The parties are banging heads against each other in a life or death struggle in arbitration, but their deal is still going on. And they're not going to escape the contract either. They will still be bound to it. So what is beginning to happen is trying to find ways in which these differences can be resolved short of formal dispute resolution and more in the nature of renegotiation. So to take you back to the relationship analogies, how to rediscover the magic of courtship 10 years into your marriage. Then, Stone Age did not end because we ran out of stones. And what I just want to touch on here in finishing is the energy transition and the context in many parts of the world of the energy transition and decarbonisation. And this is very much an area for international gas contracts. Some see that natural gas is now coming into a golden age where it is the least polluting of all the fossil fuels. There are views that all fossil fuels within reasonably quick time, and the question is, what is the time in which this will happen? And for many people, today's targets and today's investment decisions are looking forward but not looking forward far enough. If you look at things like the Paris Agreement, COP arrangements, then 2050 sees carbon neutrality. Well, we're still making agreements that provide for deliveries in 2050. So, coming to a close, I would commend you to hold in mind the matter of decarbonisation. In some jurisdictions, this is not such a big matter. In others, it is. But you only have to look at what's happening to the international oil companies and how they are changing the nature of what they do, the attacks they are under from activist shareholders, or indeed under climate change litigation, to see that these moves are happening. Can you provide for them in your contract today? Well, that's the question. So, as Einstein said, the world we've created is a process of our thinking. It cannot be changed without changing our thinking. Finishing, in the money or out of the money, which camp are you in? The rule of law or changing circumstances? Are relational contracts different? English law is moving to the view that they probably are. Looked at some recent cases, and I can follow up on those. And do not forget decarbonisation and the energy transition. Ending with Einstein again, in the middle of every difficulty lies opportunity. So thank you very much, and hand back to Jocelyn as our moderator.
Thank you very much, Professor Griffin, for this wonderful webinar. We are now going to invite any questions from the floor.
Or even online, so you can type on and tell them you're inviting questions. So for me, the question I have is, what is the basic difference between gas contracts and oil contracts, and what should policymakers or experts look out for when they're negotiating these two contracts?
Yeah. The difference between gas contracts and oil contracts really nowadays represents the difference in the markets and the trading of oil and gas. So there was a time when both oil and gas were sold on long-term arrangements, and those arrangements were local or at best regional. The real difference with oil was when oil became a globally traded commodity, and there was a price of oil which was broadly recognised. Now clearly there are different categories of oil if you look at a Brent price versus a West Texas Intermediate price, but essentially crude oil is a commodity which is transparently priced, and there is a liquid market. The difference is transportation costs, but broadly people are comfortable that they know there is a functioning market, and you can take your decisions on, are you going to carry out an oil development, because you will be able to sell your oil at a price, and you can make your assumptions on what those prices are. The contracts related to that market are short. They don't need to be long, because nobody needs a long-term support or guarantee of being able to sell their product. Gas is still in that era where there is not yet global pricing. There is a gas price in the Americas, a gas price in Europe, a gas price in Asia Pacific, possibly, but there are very few liquid, transparent gas prices. In the US, the Henry Hub marker, in the UK, where we are today, the NBP price, Northern Europe, TTF in the Netherlands, but much gas is still traded by reference to oil prices. So oil is that liquid market. And the contracts reflect this. So for many people in the gas business, in order to make the investment decisions, they will look for a long-term guarantee of a price or a reliable price. And the contracts show that. Gas contracts have been changing. As I mentioned earlier on with aggregators and traders, there are now more framework agreements, short-term arrangements, and you can trade a cargo of LNG in the way you can trade a cargo of oil. But gas still has an underpinning of long-term arrangements.
Okay. All right. We have a question from Yazadi. In the case of price dispute for the long-term contracts, what's your definite notice to avoid long and costly delays by renegotiations of terms of price formula?
Well, that is a great question, and I'm sure there's a magic answer to it, but nobody's yet found that one. The difficulty of resetting prices partway through a contract is what has led to very many international arbitrations and expert determinations over recent years. What the parties are trying to do is to identify that the circumstances have changed. And one party will be arguing that they have because they're out of the money, and the other party will be arguing they haven't because they're in the money. That's a purely temporal matter, because if the market shifts, the same parties will be arguing the opposite because they're on the other side. But how you get through that, if you have to resort to the contract, then typically arbitration is how the parties have done it, possibly expert determinations. But what you're really looking at is you're rewriting the agreement of the parties. So if you can prove that you are in the clause at all, the trigger, as it's called, has the trigger been met? The circumstances, a change in prices by more than X percent, change in market, again the clause I've put in here. If you can get into the clause, that's test number one. Once you're in the clause, what is the market? Big question. Typically the market was quite local. Europe was Europe. These markets are shifting as greater trades are happening. So there is no easy answer to it. You can certainly make your life easier by making shorter term contracts. Necessarily, the shorter the term, the less the risk of circumstances changing, but that may not be an opportunity. And you only need to look around many parts of the world where LNG, and LNG is the best example here, LNG production is now reaching great rates, and clearly over the coming years will increase from that. The parties are still making very long-term agreements. So it is a very difficult question to answer. If there is a mood, I would say the mood is to seek to renegotiate rather than to enter into formal dispute resolution.
Great, thank you very much. Just a minute. We have another question from Pooja. On dispute resolution, is it just international arbitration that is suitable? Laws in emerging natural gas producing countries do provide for international arbitration using local arbitration laws. Is that appropriate? Or what elements should the local host arbitration law have?
Again, big question. I would say that the nature of the international gas business does lead to arbitration as the means of resolution. Local courts are unacceptable to a foreign party. Typically, local laws may apply, but the process of arbitration, in order to bring the dispute out of the locality, will normally prevail. There are examples in the courts, and I edit a book called The Law and Business of LNG, which if you have the chance to have a look at it, you'll see there's a piece in there which I wrote which covers court actions. Those are comparatively unusual because we're in an international arena. Pipeline gas can be more local, because even international pipelines start somewhere and end somewhere and they're fixed. Obviously vessels in LNG are not. I would say that the combination of the governing law of the contract and then the law of the arbitration, the seat of the arbitration, and very often the institution for the arbitration are all more important than ever before. And I think before the parties began to exercise their rights to go to arbitration. These discussions tended to be non-commercial. They happened at the end. The parties did the commercial things, and then at the end the lawyers put in an arbitration clause. Having now operated the clauses, many people will say, actually, I need to have this up front, because if this happens, this is going to be very significant. And I think within the price reopeners, the Atlantic LNG case, which is one of those in the book, was for many people the alarm call that said, when we write a price reopener and we say that we are going to agree a new price and we will do what is fair and reasonable, but if we can't, then the arbitrator will decide. That award in that arbitration was appealed to the court, and the court said, well, you gave your ability to make a contract and to agree what was fair and reasonable to third parties who are the arbitrators, and they did that. So you can't now question what they've done. So that was, I think, for many people quite shocking, alarming. The making of the deal for the next 5 years, until the next price review, had actually been given over to third parties who, well, in that case, were lawyers. Many commercial people at the beginning would have said, I'm not having my commercial deal made by lawyers. But that's the consequence. Very difficult one to resolve.
Okay. We now have a question from Jeremy.
Yeah, thank you. I wanted to get your opinion, or rather, do you see a paradigm shift in project financing new LNG projects following the energy transition issues? And also based on the latest Equator Principle 4, which suggests where the Equator Principle financing institutions agreed to comply with the Paris Agreement and take into account tackling climate change, and as well as conduct climate change risk assessments. And so I believe these institutions are majorly involved in large LNG projects. And do you think this would affect the future of project financing LNG going forward?
I do, and I think those changes are beginning to happen. And it's one of the reasons why I wanted to bring into the presentation today energy transition and decarbonisation. Financing of LNG projects, I think, is changing anyway. LNG projects are now so diverse. If you look at the United States, before long may well be the leading exporter of LNG. The financing of those projects is completely different from the classic project finance market. If you look at the way in which trading and aggregation has happened, part of that has been fed by the fact that there are existing facilities now. There was a time when if you wanted to create an LNG facility, it was a new one. Now, if you look at places like Qatar, where original facilities have been long amortized, the considerations are different. Nigeria, as it's now going through its next phases. So those elements have all been different. But for me, that's not of the same consequence as the sorts of moves that you mentioned, quite rightly, where the influence is now on the provision of money, the availability of money, have to take into account greater and broader interests. Many of the developments in the LNG business are supported by export credit agencies. Export credit agencies, together with multilateral agencies, will often bring with them the terms of those who provide the finance and provide the funds, and they will increasingly bring with them the obligations of environmental, social, governance requirements. And for me, it's difficult now to say, well, it doesn't really apply to us. These things do. I don't know what the answer is, but the point is exactly right.
That's the question. Yeah. Yeah. And then I wanted to really look into the issue of decarbonization and transition into a low carbon economy. I know, like, internationally and globally, they're putting focus on that, and we're seeing lots of countries taking initiatives to decarbonize the energy sector. Like in the EU, there are different initiatives being taken. But now I have a feeling that we are losing touch of what's going on in developing countries, in most developing countries, because the international arena there, it's like more of a myth. They think like all the countries are at the same level of, decarbonization, but we forget that different countries face different energy challenges. You look at sub-Saharan Africa, in most countries, people are being faced with the issue of energy access. We have people in rural areas that are still relying on traditional biomass, on firewood. And then on the other hand, we have developed countries that are really moving forward with decarbonization. So we are losing touch with the national initiatives and national energy challenges, and also the international energy initiatives and international energy challenges. So my question is, isn't it more of a hypocrisy for the developed world mostly, because they're the ones who are pushing forward for these initiatives? So it's more of forcing, because you're looking, you mentioned yourself, like most oil companies now, they're looking into decarbonization. If you look at the World Bank, they're cutting down finances and investments with respect to fossil fuels. So is it more of a hypocrisy whereby the developed world, they feel we have the money to move forward, we have the capacity, we are no longer faced with energy access challenges, but mostly it's more of energy security. And now you look at developing countries where most people are still relying on firewood, they are progressing to say, okay, what other modern energy can we consider? But now you have these big people saying it's time to decarbonize. We all have to move at the same pace. So I feel it's more of a hypocrisy from my part, because I've written a lot on energy access issues in sub-Saharan Africa, and I've also written on transition into a low carbon economy. And I've also looked at the EU initiatives. I've done papers and I've worked on an EU project, and I see the money in the EU and how they're moving forward to that. It's not compared to what African countries are experiencing. So in your experience as an expert, what do you think should be done to ensure that we are all at the same level? Like, no country should be left behind with respect to decarbonization and transitioning to a low carbon economy.
Yeah. Well, I think you make the point very well, and I think it's a very sage consideration.
Yeah.
And I think it is. It's an emotional area as well, and I think one of the comments which I find particularly striking from a number of developing economies is, well, how can you attach these standards to us when we are still creating our economy?
Yeah.
You have the advantage of having done all this. Allow us to develop our economies before you then come along and tell us that we have to do these particular things.
Mm-hmm.
And I think that's very powerful. And there are a number of powerful influences. I touched on climate change litigation earlier on, which, if you look across the world, the US is where most happens, but actually climate change litigation is across many parts of the world. The emotions there are also very strong in terms of, well, if you are developing fossil fuels and you're producing hydrocarbons, then the environmental social governance requirements are very strong and have to be put in place. But it's not enough just to now carry out activities for the future. What about the past?
Mm-hmm.
You can't just overlook that. There needs to be compensation, reparation for what's happened in the past. And that's led to, in many ways, young people, one of the climate change litigation matters in the US, of children bringing actions about their future. Very powerful. The primary issue that you touch on, though, I think is a very important one, that when you look at the measures to be taken and how they're to be taken, there are sort of global initiatives, but how are they implemented? Well, they're implemented locally, and locally is different from place to place. And I think the way in which that moves is one of the main considerations here. If I come back to the subject today, international gas contracts, here you have production typically in one jurisdiction, consumption in another. Well, those two are likely to have very different ideas of carbon, decarbonisation, growth of economy, taxation, fiscal developments, carbon taxes, and at the moment there are initiatives which are global, but implementation is local. And bridging those, to me, is I'm not sure what the answer is as to how you bridge those, and still less do I know how you write in your international gas contract how to take account of those different steps. But I think the point you make is exactly right, and that's why I say, certainly as I've heard it put, you cannot dictate on what we do before we've even had the opportunity to develop in the way that you have. These are just not rules that can apply across everybody.
We have one more question. In the case of the linkage of gas prices to oil prices, what are the term differences in a spot deal and long-term contracts?
Well, I would say in a spot deal, if you're looking, again, nice example is LNG. If you're looking at a spot deal of a tanker of LNG, then there is no real linkage at all. There is a market for an LNG delivery into a European terminal, an Asian terminal, and the price for that cargo on that day will be the price referable wholly to a gas market. But as the contracts become longer, then the risk of agreeing a single price, which will become different from the market price from time to time, is greater. And the question is how you manage that risk of your fixed price running into the future diverging from the market price. And some people will manage that by reference to oil prices. There are market prices for LNG. As I mentioned earlier on, in Europe, the US not so relevant because of its production nature. The JKM index in North Asia. But how to find a measure which allows your price as you agree it today to remain representative of markets into the future is the nub of this. With a spot contract, you just don't need to. But there are lots of ways of doing it in gas. And at the same time that you're projecting into the future, obviously the changes that we've been discussing are coming forward as well. And one of the big questions is just what are the timescales that we're looking at? And there is a view, just coming back to the question on decarbonisation, that the projections which are now current are not taking account of how quickly the changes are happening.
So thank you very much for this session.
Pleasure. Thank
we
you.
have come to the close of our webinar today, and we look forward to the next webinar.
Thank you.
Thank you
Me
very
too.
much.
That's a
Thank you
pleasure.
very much for
Thank you for inviting me.